As the national community reels over the early release of Alexander Clack for the gruesome murder of his late wife in 2014, legal experts and citizens alike are attempting to make sense of the circumstances that led to his release on a technicality in the first place. Clack's criminal defense attorney, Anselm Clouden, advanced the view in media interviews last week that the case was dismissed on account of a stolen computer which contained the case transcripts. The attorney pointed out that the court registrar could not produce records of the court transcript during his client's appeal hearing.
What has become of the transcript? And the registrar advised the court that in fact the computer that had the recordings of the judge was stolen.
However, Attorney Ruggles Ferguson, in an appearance on the Bub Report, advanced a different view, suggesting that most of the transcripts were in fact available, except for portions of the audio transcript which was inaudible. Whenever a grounds of appeal request is filed at the Court of Appeal, this automatically triggers the production of transcripts from the lower court, which were made available in the adjudication of this matter.
So what has happened in this matter is not that there was no transcript. As I understand it, 95% of the transcript was completed according to the registrar. 95% was completed. However, the part that dealt with the summation of the judge, the audio of that particular day, apparently, so the entire trial is taped, and for that one day, when the summation was done, the audio, there are some issues with the audio. But what has not happened is that there's no stolen computer.
Ferguson cautions the national community to not conflate the recent allegations of computer theft within the confines of the court with this matter, emphasizing that a paper trail does exist in all cases being adjudicated at the courts.
There were computers stolen recently from the registry, as far as I understand. Very recently, that had nothing to do with this case. And that had nothing to do with Israeli computers, and no information is missed because it's backed up in the cloud based on the system that is used.
The acquittal of Clack, who pled guilty to murdering his wife, raises salient questions about Grenada's state of court administration. The Grenada Bar Association brought 2 civil suits against the previous administration, advancing the view that they failed to make resources available for the efficient functioning of court administration in the jurisdiction, which is in breach of Section 8, Subsection 8 of the Grenada Constitution. Reporting from Washington, D.C., this is Dr. Kellen Bubb.